to the workshop on intellectual property rights organized by the DPIIT-IPR chair, IIT Dhanbad. We are honored to have with us today an esteemed guest, Dr. Sudipta Banerjee. Dr. Banerjee holds a PhD in inorganic chemistry and is a registered patent agent with over 29 years of experience in intellectual property rights. With her extensive expertise in patent drafting, prosecution, and litigation, Dr. Banerjee has established herself as a respected voice in the field. She has delivered lectures and participated in panel discussions at various prestigious forums, including the National Research Development Corporation, CII, and other esteemed institutions. Let's give a warm welcome to Dr. Sudipta Banerjee and look forward to her valuable insights and expertise. And felicitate our distinguished speaker, Dr. Sudipta Banerjee.
I see.
Hello, a very good evening to all of you here, and I'm really thankful to our respected Dean, Sir, Chair Ma'am, and all the organizers who have given me an opportunity to be here before all of you today. And we would try that to make this session as interactive as possible so that I know after the whole day's work and classes, to listen to IPR at a stretch for 2 hours is difficult. Because I was also a part on your side, I have seen how it is. So let's make it interactive. I'll try and give you more examples so that if you have any questions, you can even ask me in between, or we can wait for the part to finish and then ask questions. I leave the choice to you people, how you want to do it. Okay, so my background, already you know what my background is. So let's start the presentation. Like, what is intellectual property? I think we all know from the word intellectual property means it is something which is created with the intellect of a person. It can be an invention, book, paintings, whatever it is. But what is intellectual property is what is prepared with your intellect capacity, what you have made. And this intellectual property is actually called intangible property. Because properties here, we learn about two properties. One is intangible, one is tangible property. Intellectual property especially comes into the regime of intangible property. And now the next slide, if I show you, this is the property which is called tangible property. Tangible property is what you own, the car that you have, the house that you have, the land you can sell. Even with intangible properties also, you can handle intangible properties in the same way like you do the tangible properties. You can sell, you can assign, you can give it to some other person, like you can sell the land, property, your car, whatever you have. So these are the two types of properties, and IPR falls into intangible properties. Now, we have different kinds of IPRs. When we started our profession long back, as you have heard my background 29 years back, there were only design, trademark and patents, mainly copyrights. But now, with the development, we have now semiconductor, IC layout designs, we have biodiversity and traditional knowledge, we have trade secrets, we have plant variety. There are so many other parts of IPR which is under one umbrella term of IPR. These are also different kinds of IPR. Now, once we get more into details, we'll know each one how they are. Yes.
Excuse me. I just wanted to know, like, very briefly, how is a plant variety an intellectual property? As in some genetic mutations that have been
Yes, yes. When you bring in new species of plants with the genetic care, then the new species that the farmer makes, they get a protection for that.
Thank you.
So now, to start with, we will go for patents. What is a patent? Patent is an exclusive right which is granted to the inventor, which provides an exclusive right to the inventor and all others who are prepared, prevent them from making. What happens? This is an exclusive right. Why do we call patents an exclusive right? We need to understand that. Exclusive in the sense, when you are making an invention, once you have come out with a patent, so you are excluding others from preparing that. You are stopping others from making that particular invention. So therefore, this right is an exclusive right, and it excludes all others, prevents everyone from making, selling, or importing your invention. So what is patent? This is what we have to keep in mind for patents. Patent is a right to exclude others from making it. Now, from an invention to be patentable, what are the requirements? When do we call that the patent is a particular invention that you have developed is patentable? So it should be new, non-obvious, and it should have an industrial applications. Now, these terminologies of novelty, inventive step, and industrial applications, we will get into details when I discuss patents in details subsequently. Now, what we have is a right of a patentee is only for 20 years. The monopoly is given by the government to the inventor for a term of 20 years. Now, this patent right is what is a quid pro quo system. Why do we call it quid pro quo system? Because when you are giving your disclosure to the government for the invention, government in return is giving you a right for a particular period, which is 20 years. This is patents. It's a little different from the other properties. Now we come to design. Now design is given protection. Design is simple, very simple. In design, only thing that is required is novelty. You don't require inventive step in design. For designs, what happens is the shape, pattern, arrangement of the lines or colors combination, how the object looks. What you look with your naked eye, that is the protection given by way of designs. And design is registered for a term of 10 years, and you can extend that for another 5 years. So total term for design is 15 years. Now, what should be there in a design? Like we have learned the criteria for patents, is novelty, inventive step, and industrial applicability. So in the case of design, it should be new. Novelty requirement is there in design as well. A new design does not necessarily mean a completely new one. If you have something of that kind earlier, if you make development in the outer surface of that, you can have protection for that. Like you can have you must have seen 10 different types of bottles. Kinley bottle, then you have different, any one you name about. But each design pattern, they're all bottles. It's not that you have come out with some invention that is a different thing from bottle. No, it's bottle. But the shape and configuration makes it it can be protected under design. So not disclosed, but it should not be disclosed to the public. As I said, the main requirement for design is novelty. It has to be new. And then comes, and it should not be against the morality, of course. And design is not functional in nature. If any product has any functional features, then that is not patentable and that is not registerable under designs. It is only the shape and configuration, how you look at it at the that's why we have protection under design for a number of mobile phones, all different kinds of mobiles, number of jewelries, because this is how one looks different from the others, but the one that you have developed is not known to anyone. It's new. Now we come essentials of designs. It should be eye-catching feature, like what I was saying, and with naked eye how it appears. It should be new and original, applicable to any article by any industrial process, should not be functional, and should not be artistic. You cannot have a jar on it and you draw something on it and you go for a design protection. No. The design, the shape and configuration has to differ of that jar. You might have a design on it, The design, you might have a painting on it, but not the painting is not right. It's the shape and configuration of the jar that is, and the painting goes along with it. Then comes trademark. Sorry, my phone is ringing. I can just put it on. I'm sorry.
No problem.
Sorry, my apologies. Now, next comes trademark. Trademark is any name, word, sound, numeral, color, symbol, anything that we call, say for example, Godrej. Godrej is a trademark. Godrej is a mark going on for so many years. When we hear Godrej, we immediately know what the goods are of Godrej and how should we rely on this mark. Why should we buy that product? So these are the things that trademarks gives us. Because today you buy an Apple phone, you have a Samsung phone, you know I'm going for Apple, you know I'm going for Samsung. That's the trade name that gives the identification to that product. So that is very important in trademarks. Trademarks lets us identify the goods made for services offered by a company or an individual. Trademark is registered for 10 years. And then it's a perpetual renewal, because as we all know, today if I have Apple registration for a term of 15 years, tomorrow that right goes, then you cannot have another registration for Apple. So therefore, it's a perpetual right which is given to a company who is manufacturing for a lifelong. As long as you keep on renewing it, it's your right. That's what trademarks is. Trademarks is little different from patents. Trademarks is the more you use the trademark, more it is in use in the market, it makes your stronger for registration. It's not like patents. Patents, it has to be new, but trademark need not be new. You have to prove the use of that. Hello, a very good evening to all of you here, and I'm really thankful to our respected Dean, Sir, Chair Ma'am, and all the organizers who have given me an opportunity to be here before all of you today. And we would try that to make this session as interactive as possible, so that I know after the whole day's work and classes, to listen to IPR at a stretch for 2 hours is difficult. Because I was also a part on your side, I have seen how it is. So let's make it interactive. I'll try and give you more examples so that if you have any questions, you can even ask me in between, or we can wait for the part to finish and then ask questions. I leave the choice to you people, how you want to do it. Okay, so my background, already you know what my background is. So let's start the presentation. Like, what is intellectual property? I think we all know from the word intellectual property means it is something which is created with the intellect of a person. It can be an invention, book, paintings, whatever it is. But what is intellectual property is what is prepared with your intellect capacity, what you have made. And this intellectual property is actually called intangible property. Because properties here, we'll learn about two properties. One is intangible, one is tangible property. Intellectual property especially comes into the regime of intangible property. And now the next slide, if I show you, this is the property which is called tangible property. Tangible property is what you own, the car that you have, the house that you have, the land you can sell. Even with intangible properties also, you can handle intangible properties in the same way like you do the tangible properties. You can sell, you can assign, you can give it to some other person, like you can sell the land, property, your car, whatever you have. So these are the two types of properties, and IPR falls into intangible properties. Now, we have different kinds of IPRs. When we started our profession long back, as you have heard my background 29 years back, there will only design, trademark and patents, mainly copyrights. But now with the development, we have now semiconductor, IC layout designs, we have biodiversity and traditional knowledge, we have trade secrets, we have plant variety. There are so many other parts of IPR which is under one umbrella term of IPR. These are also different kinds of IPR. Now once we get in more into details, we'll know each one how they are. Yes.
Excuse me. I
Yes.
just wanted to know, like very briefly, how is a plant variety and intellectual property, as in some genetic mutations that have been introduced?
Yes. When you bring in new species of plants with the genetic care, then the new species that the farmer makes, they get a protection for that.
Thank you.
So now, to start with, we will go for patents. What is a patent? Patent is an exclusive right which is granted to the inventor, which provides an exclusive right to the inventor, and all others who are prepared prevent them from making. What happens? This is an exclusive right. Why do we call patents an exclusive right? We need to understand that. Exclusive in the sense, when you are making an invention, once you have come out with a patent, so you are excluding others from preparing that. You are stopping others from making that particular invention. So therefore, this right is an exclusive right, and it excludes all others, prevents everyone from making, selling or importing your invention. So what is patent? This is what we have to keep in mind for patents. Patent is a right to exclude others from making it. Now, from an invention to be patentable, what are the requirements? When do we call that the patent is a particular invention that you have developed is patentable? So it should be new, non-obvious, and it should have an industrial applications. Now, these terminologies of novelty, inventive step, and industrial applications, we will get into details when I discuss patents in details subsequently. Now, what we have is a right of a patentee is only for 20 years. The monopoly is given by the government to the inventor for a term of 20 years. Now, this patent right is what is a quid pro quo system. Why do we call it quid pro quo system? Because when you are giving your disclosure to the government for the invention, government in return is giving you a right for a particular period, which is 20 years. This is patents. It's little different from the other properties. Now we come to design. Now design is given protection. Design is simple, very simple. In design, only thing that is required is novelty. You don't require inventive step in design. For designs, what happens is the shape, pattern, arrangement of the lines or colors combination, how the object looks. What you look with your naked eye, that is the protection given by way of designs. And design is registered for a term of 10 years, and you can extend that for another 5 years. So total term for design is 15 years. Now, what should be there in a design? Like we have learned the criteria for patents, is novelty, inventive step, and industrial applicability. So in the case of design, it should be new. Novelty requirement is there in design as well. A new design does not necessarily mean a completely new one. If you have something of that kind earlier, if you make development in the outer surface of that, you can have protection for that. Like you can have you must have seen 10 different types of bottles. Kinley bottle, then you have different, any one you name about. But each design pattern, they're all bottles. It's not that you have come out with some invention that is a different thing from bottle. No, it's bottle. But the shape and configuration makes it protected under, it can be protected under design. So not disclosed, but it should not be disclosed to the public. As I said, the main requirement for design is novelty. It has to be new. And then comes, and it should not be against the morality, of course. And design is not functional in nature. If any product has any functional features, then that is not patentable and that is not registerable under designs. It is only the shape and configuration, how you look at it at design. That's why we have protection in under design for a number of mobile phones, all different kinds of mobiles, number of jewelries, because this is how one looks different from the others, but the one that you developed is not known to anyone. It's new. Now we come essentials of designs. It should be eye-catching feature, like what I was saying, and naked eye how it appears. It should be new and original, applicable to any article by any industrial process, should not be functional, and should not be artistic. You cannot have a jar on it and you draw something on it and you go for a design protection. No. The design, the shape and configuration has to differ of that jar. You might have a design on it. The design, you might have a painting on it, but not the painting is not right. It's the shape and configuration of the jar that is, and the painting goes along with it. Then comes trademark. Sorry, my phone is ringing. I can just put it on. I'm sorry.
No problem.
Sorry, my apologies. Now, next comes trademark. Trademark is any name, word, sound, numeral, color, symbol, anything that we call, say for example, Godrej. Godrej is a trademark. Godrej is a mark going on for so many years. When we hear Godrej, we immediately know what the goods are of Godrej and how should we rely on this mark. Why should we buy that product? So these are the things that trademarks gives us. Because today you buy an Apple phone, you have a Samsung phone, you know I'm going for Apple, you know I'm going for Samsung. That's the trade name that gives the identification to that product. So that is very important in trademarks. Trademarks lets us identify the goods made for services offered by a company or an individual. Trademark is registered for 10 years. And then it's a perpetual renewal, because as we all know, today if I have Apple registration for a term of 15 years, tomorrow that right goes, then you cannot have another registration for Apple. So therefore, it's a perpetual right which is given to a company who is manufacturing for a lifelong. As long as you keep on renewing it, it's your right. That's what trademark is. Trademarks is little different from patents. Trademarks is the more you use the trademark, more it is in use in the market, it makes your stronger for registration. It's not like patents. Patents, it has to be new, but trademark need not be new. You have to prove the use of that, how long you have been using it, and what impact it is giving to the, and you have to just continue with it, with the mark. And it's a perpetual right given by the government as well. It can be renewed for lifelong, as long as you want to continue with that mark. These are some important trademarks, as you all know, Apple, Nike, and Audi. Now, essentials of a trademark. Trademark advisable is what you should what you should avoid, and what should be done. It should be distinctive, non-dictionary words, and custom devices for symbols, and non-descriptive. Because you cannot have a mark for a wooden thing and you say it as woody. Because that name itself says it's made of wood. And that is a description, it's giving the goods description. That cannot be a trademark. So these things we have to keep in mind when selecting the name, or you want to go for registration in trademarks. It cannot be, what you have to avoid is adjectives. Name of a person, obscenity, religious or constitutional words, and common shapes in trademarks. Now, I'll tell you a recent thing that is going on in the Delhi High Court is, you all are, wow momo. Wow, even chicken. There's so many wow things come out. Now, wow people wanted, there's something called wow burger, which is in some other, now wow momo is wanting that wow word for themselves. They're saying that's a word actually wow is a word, we all know, it's an exclamation. We say, wow, this is so beautiful, wow. So Delhi High Court has not given injunction to them, and they said wow cannot be monopolized. That word cannot be. You can have a protection for wow momo or wow burger in totality, but wow word you cannot have for yourself. This is a current layer in September in Delhi High Court. So this is all you have to keep, you be careful about when selecting a mark for registration for trademarks. Now to trademark, if you look at the sign, if you see TM written on it, that means it is under processing. If you see a mark R with that name, that is it's a registered trademark. That's how you distinguish. Now what is copyright? We all know copyright is an exclusive legal right which is granted to the creators. Even a producer has a copyright, singer who's singing has a copyright, even who's making a movie, who's writing the script, everybody has his or her rights in copyright. Copyright is not mandatory actually. Anything that you make, you write a book or you write a poem or you develop a software, whatever it is, that is a copyright on its own, that is your product. So you need not go in for registration also in case of copyright. But copyright is required to be registered to stop other people using the same thing. Then the court requires whether you have registered your product, your copyright or not. That's to prevent others from using the same copyright. You approach the court for copyright protection. It is recommended to register a copyright for better enforceability, since registered copyrights have evidentiary value in court. Now, various copyrights are right of performers, rights of producers, rights of music director, rights of title song, rights of broadcast. These are the different kinds of copyrights that are given. Now, then comes geographical indication. Geographical indication, the famous case was Rasgulla from Odisha and Rasgulla from Bengal. The two had fought in the court. Anyway, now both are registered. Now, registration of geographical indication is a name or sign used to certain products which corresponds to a specific geographical location. This is like Darjeeling tea is from Darjeeling. We know it is from Darjeeling. Rasgulla we know is from Kolkata. It's like that. It is a right not given to a single person. It is a right given to a community of people developing that product. It's a community right. It's given to a group of people engaged in preparing that product. So GI is totally different. Like for patents, the single person gets a protection. For copyright, but GI, it's a community right. It's given to a group of people who have developed that product. Now these are the tags that we have already procured. These are all from different places in India, like Kerala, Tamil Nadu, then you have Bihar, you have Madhubani paintings from Bihar, then Kulu shawls. These are all from different provinces, whatever has gone through for GI protection in India. Then comes geography. This is some examples I've just brought for West Bengal. These are the ones that I think many more have been added now. Darjeeling tea, Katha stitch from Bengal, Malda mango. All these are there. Shantipur sarees, Baluchari sarees. So these have already got protection. And these are protection given to the community of people developing it, not to an individual. Now comes plant varieties. Somebody asked me a question just now. Plant varieties. Plant varieties is such protection is a unique aspect of Indian IP regime which recognizes the farmer as cultivator, conserver and breeder. Because the farmer is making the change, they are developing the new variety. So it's a protection which is given to the farmer as cultivator, conserver and breeder. The Protection of Farmers Act 2001 grants intellectual property rights to farmers and plant breeders who cultivates or develops any new or extinct plant varieties which are not there. It is different. They have developed, like for example, pearl millet rice, gram, black gram, types of green grams. These are all under plant varieties. So these are the new species that they have developed, which was not there earlier. Now, traditional knowledge. Traditional knowledge is, all of us know that it goes back with haldi as an antiseptic and neem as an antifungal. That was first from India, and therefore, so many disputes have taken place with USPTO and all with haldi and neem. But ultimately, we have developed a digital library where we have preserved these things, and this is even shared with patent offices also. So therefore, if you come across biotechnological inventions, especially with pharmaceutical compositions also, what happens? Lot of citations from the patent office comes from traditional knowledge. They say this is already known. This combination or composition of what you have developed is already known. So there you get to see citations from traditional knowledge library also. Lot of them. Ministry of Ayush now, a lot of people are working on this to preserve this property. Trade secret. Trade secret, as we all know, trade secret is there for KFC and Coca-Cola. We all know about this. And this is where trade secret can be protected for an unlimited period of time. But just now I learned from you that they have already started working on the laws are already framed. It has to be finalized for trade. But previously they did not have trade, any law for it. So it is to be protected under contract law or through the equitable doctrine of breach of confidentiality. That's how it has been protected for so many years, Coca-Cola and all. But now the law comes in, so it will be a different protection once it is finalized. Then comes IPR examples. I'm just giving you one example, which in one thing, how many protection can you get? It's a Sony TV. You have your trademark Sony. Then you have copyright for the manual of the Sony TV. Then you have design for the Sony, and also an invention how you have prepared and how you have developed that TV. So it is not necessary that if you develop something, you can only have protection under patents. Maybe the way you have developed it, whatever, it might have a protection in design as well. You can go in for two protections, patents and designs. Or you can go patent, design and trademark if you want to have a mark for that particular invention that you have developed. So therefore, one product can have n number of protection now in our country. Now, these are the summary with the time period because it's nice to have it. Like patents for 20 years, we just learned. Design is for 15 years, 10 years plus 5 years. Trademark is perpetually, you can keep on renewing it indefinitely for 10 years each time. Geographical indication is 10 plus 10% renewed indefinitely, like in the case of trademark. Copyright is the life of a person plus 60 years, author plus 60 years of his life. Semiconductor integrated for 10 years, IC layouts, and plant variety is for different crops 15 years, trees and vines 18 years. So this is very useful, like sometimes when you refer to how many years I'm going to get a protection. So it's a handy thing to have that this is the protection that is given. Like Ravindra, for his for a lifetime, he has gone for copyright. It's more than 60 years now after he passed away. So these are the ones that we normally. Now comes patents. So do you people want a break or want to ask some questions on this part, or now I get on to patents in details? If you have anything, yes, please.
Ma'am, how fruits can be you said that the community rights, a group of people developing some GI tag. How fruits can be considered as a GI tag of that particular area? Fruits. You said the Malda fruits.
Malda, mango, and these are protected. Like you have Darjeeling tea. Tea is also a product of the plant only. But because in that geographical condition, in that area only that particular fruit can grow with that taste, that particular taste. Maybe if you take a seed and grow it in some other part of country, you will not get that taste. So it's the geographical, the conditions around this, like how Darjeeling tea is developed. You cannot have Darjeeling tea in Assam. Assam tea is not a different tea than Darjeeling tea. Similarly, mangoes also, what you grow in Malda, you cannot grow in any part. Therefore, it is protected under Malda and Malda mango, because it says the temperature, the conditions, climatic conditions has lots to contribute in the taste of a particular, fruit or tea or whatever. Crops. So that is what Malda is restricted to Malda. Yes.
I have two questions. Like the first one is, we cannot trademark dictionary words, but we can trademark phrases, right?
Yes, you can have word marks.
And the dictionary does not apply. But it's a proper phrase.
Proper phrase, but that is not under trademark. I think that comes under word mark or something like that.
Okay.
Because trademarks also has different types. For phonetic ones, like you have Nokia tune, the sound of Nokia. The moment you hear, oh, this is a Nokia one. So you have that sound protection also under trademarks. This way, there are different kinds in trademarks.
Okay. And similarly, in patents, do we have categories like pharmaceuticals will have different patent laws? And some
Yes. If you compare with pharmaceutical, yes, it's a different law, because in case of, since you've asked me for pharmaceutical, I'm just explaining you. Like laws is the same. It's the criteria is novelty, inventive step, and industrial applicability. These three has to be there. But besides this, when we get on to the next one, and when I come into the details, I'll tell you there are certain provisions in the Act. There is a section 3 in the Act, which even besides being novelty, inventive, and industrial, still if it falls into that purview, then it becomes non-patentable. Especially in the case of pharmaceuticals. Now, depends what pharmaceutical product that is. If it's a new product by itself, okay, then novelty, inventive, and industrial applicability applies. But if it is pharmaceutical composition, for example, then in that case, if it's a pharmaceutical composition, then it will not be only looked into by novelty, inventive step, and industrial applicability. But in that case, we will also have another law, 3E, section 3E, which says that an admixture cannot be patented. So you have to prove that composition has synergism in it, which is contributing to that composition, and then it becomes patentable. So, these laws are there. It is not that the law differs, but there are certain negative laws in our country, section 3, which has to be read with novelty, inventive step, and industrial applicability.
Ma'am, if you're talking about the trademark, like for an example, Adidas shoes are having their trademark. So nowadays, many sellers are using their trademark in local market. So how they are securing their trademark from their sellers?
They have their systems where they send their people to those remote villages where things are developed, and they take away all those goods from time to time. They're snatched away and they're taken into police custody. All that takes place in trademark a lot.
But still, we are seeing like many.
I know. Our country is meant for China and India are the two countries which are all the time copying products. What can you do? Even the foreigners know that. When they come into with a trademark here into India, they are very scared with the product. It's a new product, because they know Indians are capable of copying products. So therefore, all the time there is a search facility in trademarks besides trademark filing. Even our office provides that. There we go into the remote villages when we come to know that this product is being copied, like especially the spare parts, the vehicle spare parts of this the two-wheelers and four-wheelers. Malda is a famous place there. All the time somewhere or other there's raid going on, police is taking away the goods and all. Again they come back to square one. That's what is. But there are laws to stop. Yes.
Suppose we develop an application or anything online platform and we bring out some special feature in it, then do we get any type of protection for that? Suppose taking example of hybrid feature which was introduced in ChatGPT. So is it protected under any law?
Application in the sense, what application?
Means any online any online platform we create and we bring a special feature in it. Means we integrate something in that. Then we get any protection so that no one can copy it.
No one can copy that platform that you develop. What do you mean? I'm not getting your question.
Ma'am, suppose taking example of ChatGPT. Recently, it has introduced a Ghibli feature, which converts your image into a cartoon. So, is it protected under anything or no? Means, can it be protected by some law that no one will copy same feature in their application?
Difficult question. I really don't know. Is it under copyright? I think it's under copyright. Patent you cannot get for that because trademark also you cannot have for that. I think it would be protected under copyright because it's a artistic work, right? And that there people are copying their photograph into it and putting and it's giving a different form of it. So it should be protected under copyright.
Ma'am, not just about photograph, but any other thing. Suppose I'm supposed to give and recently it introduced, for example, it introduced a lender. It introduced a platform where someone can lend their things to other borrower.
Samna just come up.
आप बिना माइक के बोलो वो माइक बहुत
नहीं अब रहेगा दूर था दूर से करा
मतलब ऐसा मतलब ऐसा कि अमेज़न है या फिर कोई सा प्लेटफॉर्म उसने एक नया कुछ स्टार्ट किया पहले वो ग्रोसरीज बेचता था एंड अब उस पे ये फीचर है कि कुछ चीज जो आपके पास है वो उस पे ले
सॉफ्टवेयर होगा ना सॉफ्टवेयर से डेवलप होगा ना वो कॉपीराइट के अंदर जाएगा
Ma'am, he might be talking about the business models.
Business models are not patented.
Business models are not patented.
Not patented.
But whatever the copyright you are saying, right? So you are saying that Ghibli art. So the Ghibli art is protected under the copyright.
And उसके साथ कुछ और कुछ
वो भी कॉपीराइट के अंदर ही आएगा.
ओके
अगर आप ऐसा कुछ बनाएंगे कुछ दूसरा जैसा गिबली आर्ट्स के बारे में आप पूछ रहे हो वो भी कॉपीराइट के अंदर ही आएगा.
अच्छा
ठीक है ना वो क्योंकि वो आपका क्रिएशन है आप उसको क्रिएट कर रहे हो अपनी तरीके से तो वो कॉपीराइट के अंदर ही आएगा. बट जो आप ये पूछ रहे हो बिजनेस मेथड अगर है तो फिर वो पेटेंटेबल नहीं है और अगर आप सॉफ्टवेयर के द्वारा कुछ कर रहे हो तो फिर वो फिर कॉपीराइट के अंदर. Can I continue or any other questions? Then I'm continuing. Okay. So someone wanted a break? Anything? Okay. No problem.
Yes. That's so easy task.
And then understanding someone else's
Yes.
If I have developed something on my own, I can write it. But this is developed by someone else. That person has to. We have to understand that when we are drafting. Then only we can draft.
That same problem we are facing regarding that filing of examination report also. Inventor started.
Had a break. Refreshment हो गया ना. Let's get on to patents now, which is our main unit. Now patents, as we have already seen the definition earlier, but still I'm just repeating a bit and then we get on to the details. A new product or process involving, what is patentable actually? A new product or a process involving an inventive step and capable of industrial applicability. It's a term given for 20 years by the government to the inventor, and renewal fees has to be paid only after grant of a patent in India, not in advance. There are other countries like Europe where you have to pay the renewal fees from day one of filing the application. But in India, you have to pay from the third year onwards, but it is only once the patent is granted, not at this stage. Okay. The next one is, what is actually a patent? Patent is a statutory right for an invention granted for a limited period of time to the patentee by the government in exchange of a full disclosure of his invention for excluding others from making, using, selling, importing the patented product or process or producing that product for those purposes without his consent. Now comes when you are saying that, as I've told you, the procedure of patent is a quid pro quo system where you are giving the disclosure to the applicant and to the government, and government is giving a monopoly right to you in return. That's a exchange program, right? Now, what are you giving to the government? How are you disclosing your invention to the government? You are disclosing your invention to the government in the form of a specification. The document that we file with the Indian Patent Office is, we draft a specification and we file that with the Indian Patent Office. And that document is not completely technical. It's a legal and technical mixture. It's a techno-legal document. It is called techno-legal, the specification. So the specification can be of two types depending on the invention that you are making. If you are ready with your invention, you've completed all the experiments, then in that case we can file a complete specification in one go. But if you are still in the process of doing that invention but you want a protection for your date, and you want that date to be protected, because in patents date is very important, because if there are two patents on the same subject, the filing of date which is prior will be taken into consideration and not the second one. The first one will be cited against the second one in that case. So therefore, date plays a very vital role in case of patent filing. So therefore, you have to be careful. In that case, if your invention is not complete and you know within a span of 1 year it might be completed, it is almost on the verge of being complete, then in that case we normally suggest that you file a provisional specification. Now, what you file in provisional specification is just a description of the essential features of the invention, and you need not include claim or the manner of manufacture. Details are not required. Only the main crux of your invention is required for filing a provisional specification. And what is the advantage of filing a provisional? Provisional protection is for the early stage of filing date, early date, because that date will be your date for filing forever. When you file a complete, but the complete has to be filed within 1 year's time. And the second advantage here is cognating two or more provisional. If you are making, say you are doing on two different aspects, you are making invention, you are working on, so you can even join those two provisionals to make one complete specification. You can cognate the work. So that is how it goes. So therefore, these are the advantages with provisionals. Now, complete specification. Complete specification. Now, what all details we require? What are to be mentioned in a complete specification? Complete specification has a title, a field of invention, whether it's a process or it's a product, very important. Prior art, you have to give a prior art, because what you have developed, what your invention is, you have to do a bit of search and find out. That's very important, to a search and to find out as to whether your invention is really new and inventive or not. Otherwise, just filing is just waste of money. So you should do a prior art search, so that prior art background should be there of the invention. Then drawbacks of your prior art, what improvements have you made, in other words, what advantages have you made which was not there earlier in the known ones. That has to be reflected in a specification. Objects of your invention, why you have developed that invention, what is the reason that you are making. Every invention has a reason, right? So then summary of that invention, reference to the drawings. Reference to the drawings comes in the case of mechanical, electrical cases. In case of chemical cases, no reference to drawings is required. Then comes detailed description of your invention. And then comes claims, which are the main, which gives you the main protection is the claims. That is obviously not your job. That's the job entrusted to the attorneys or the law firms who are drafting for you. And then comes the abstract. Abstract and title both play a very important role when you are making search. Patent search, when you are doing any patent search, normally we first look into the title of the invention, with that we base the search, or the abstract of the invention. Abridgment of the invention is very important when the patent searches are to be done. So these are the main features that we need in a complete specification. This is a complete specification. These are the topics you have to, when you are even describing your invention or giving your disclosure to the law firm, at least try to cover these heads, not the claims. I'm not talking about the claims, but your invention should have these heads. It makes easier for us to do the job also. Now, types of claims. Claims are two types. Either it's a product or a process, but in case of product, in case of pharmaceutical compounds, you also have a composition. Composition claims are also almost product claims. That's in the frame of the pharmaceutical formulation or components. And a process claim, I have given an example of chemical, of course, because of my background being chemical. It's a process of preparing a water floatable, like this is how we draft a claim. This is just a format of how we do the process claims. And that's very important to know that there are protections are given only for product and process. That you have to keep in mind always. And in the case of mechanical, electrical cases, sometimes, very seldom, there are system claims also allowed, arrangements, but that's very seldom. That depends. System claims are allowed nowadays. The patent office now has become more and more, open. They are really trying to grant patents more and more, and they're accommodating lots of things what they used to not do earlier. Now they are taking that into consideration. With the CRI guidelines also we are seeing that. So system claims are also going through nowadays in case of mechanical electrical cases. Yes.
Ma'am, can we patent a database? Like for example, if I created a database of something, could that be patented? The contents of the database aren't mine, but I have done the process of and it is available to others. So could it be considered a product and then patented? No.
Database cannot.
Copyright.
Copyright can.
Database you can go for.
Patent you cannot go for. Patent you have to be very careful. Patent has to be a product, a technical, what you are putting in your technical effort, it's making a product or a process. That's what I said. Product and process. These are the two main things you have to keep in mind always when you are doing a patent. Whether I'm looking into the process or that, but product and process together also you can get protection if it is in the same, under the same. But database and all these all goes into copyright. Now, an invention relating to either to a product or process that is new involved, what can be patented? That's what we are now looking into. And capable of industrial application can be patented. However, it must not fall into the categories of inventions that are non-patentable under section 3 and 4. We have just discussed that. Somebody asked me a question, the law is different or not. Law is not different, but there are certain negative provisions in the Act which falls in section 3 and 4 of Indian Patents Act. Even if your product or process is novel, inventive and industrial, has industrial applicability, all the three, but if it falls into this, clutches of this, then it is not patentable. Now we go into that. Now these are the non-patentable invention. Now, like I said, if it is a composition, if it is a mere admixture, it will not go through. Even if it is novel, you think it is novel, it is inventive and all. But if it is a mere admixture, you have to show synergism in that case. So it is section 3. I did not quote the sections for you people because it becomes too legal and just kept it simple. The method of treatment and surgery is not patentable. It falls under 3I. But device, if you are using any device, that is patentable for the surgery. But the method is not patentable. So these are the things. Computer programs are not patentable. It goes under copyright. The method of teaching, learning, playing games are not patentable. Artistic creations are also not patentable. Semiconductors layout, we have a separate law altogether. Traditional knowledge, we have separate library for that. So these are the main fields which you have to keep in mind. Then in case of chemical cases, new use of a known compound is not patentable, which is under section 3D. Your product has to be new. It cannot be a use of that product that you are going to patent for. Use is not patentable in India still. So these things we have to keep in mind along with novelty, inventive step and industrial applicability. And section 4 relates to atomic energy, any invention relating to defense and atomic. If you have questions, you can ask me.
Ma'am, are patents region specific?
Yes.
So if something is, for example, not allowed to be patented in India, can it be allowed?
Yes. For example, this what I was just discussing, section like method of treatment or method of doing a surgery is not patentable in India. In India, the device may be patentable if you are using a device or something, that is patentable. But if you have really developed something like a method or something of that sort, which you want a patent and you know it's a new method that you're performing that operation or whatever it is, surgery, then you can apply for a patent directly in US. But since you are an Indian inventor, you have to procure a permission from the Indian Patent Office. There is a section 39, you have to take a permission from the Indian Patent Office before applying for that patent. Or else, alternative is, you have to wait for 6 weeks, file the patent first in India. Maybe you may not pursue it later. 6 weeks, wait for 6 weeks and then file abroad with that. But maybe you can always, once it's filed in US or the other country where you can get protection, you can abandon this application. Or else, best is quicker is to get a permission of filing in a foreign country directly. We do advise our clients when it is not patentable in India. And if that matter really has, it's a good one, so why not?
Ma'am?
Yes.
Ma'am, technologies like digital technologies like AI and like quantum computing and all, these technologies can't be patented, right? Because they are being formed due to like coding and all. And coding
No,
was a previous stuff.
in India still not.
Okay.
They are under copyright. But if you can draft the specification in such a way that you have hardware and that software and that is giving a new technical effect with it, due to that coding or that, if you can prove that that has to be done with lot of it, then there are certain patents that are going through with the new rules, new amendments. Okay, but it has to be done in a very discreet manner, that you have to show hardware, you have to show your software part also, but you have to show that conjunction of this gives a better technical effect. That can be like, for example, a welding. I'm just giving you an example. You're doing welding, everybody does. Now you have put in some software to it to make it a better way of welding it, or maybe in a short time you can weld. If you can show that technical effect with the hardware, then there are applications going through. अगर सिर्फ सॉफ्टवेयर करना है तो फिर तब वो कॉपीराइट के अंदर. Now novelty is a requirement. What is novelty? Novelty is invention must be new, original, novel, must not be published anywhere. As far as novelty aspect is concerned, if you are filing a patent in India, doesn't mean you have to look into the patents only in India. You have to look elsewhere, whole world. That invention should not be there. It should not be disclosed. So it must not be in public knowledge or use, must not be disclosed to anyone, must not be already patented. So these novelty, we just say novelty, it has to be new, but how new it should be. This is what is defining how new your invention should be that you can apply for. Next slide is inventive step or non-obviousness. Now this invention must not be obvious to a person of the same field or a person skilled in the art. In case of obviousness, we normally use this word, person skilled in the art. That is, a person who knows that invention should not feel that, अरे ये तो होता ही है, ऐसा तो होता ही था, ऐसा क्या नया हो गया. This feeling should not come. I'll give you an example here, which I've also taken up later on. If basic chemistry, so we all know. So in that, say for example, I'm doing an invention, and I've used the halogen like chlorine, bromine, iodine are the halogens we know. So I'm doing the experiment with chlorine and I'm getting an yield. I'm saying I've done it with chlorine. This is my yield. This is already patented, for example, that process. Now I'm thinking tomorrow that why in chlorine, let's do it with bromine, with iodine and try how the yield goes and what. And I'm doing it with bromine the next day. So when I'm doing it with bromine, I'm getting an yield. The invention is going, the process is running fine. So in that case, what happens? A person who's not knowing chemistry will not get this hang of it, but maybe I'm getting the result. Maybe that process is running well, but it is obvious that in case of chlorine, I can always use bromine because it's the same group of elements. So novelty to आपका pass हो जाएगा because the product that you get will be a brominated substance, not a chlorinated one. It will be a brominated, so it's new, it's novel, it's not. But as far as your inventive concept is concerned, inventive step is concerned, it will not go through because people will say inventive step, how will it go? Because आपने इतना ही तो किया है, you have just changed the halogens. It's obvious. So this is what is obviousness. So this only a person skilled in the art understands it, who knows that invention, who knows that technology, will be able to point it out. So therefore, for obviousness, we always say a person skilled in the art should not feel it as obvious. Industrial applicability is a very simple word. It's a dictionary meaning that your invention, whatever you develop, should have an industrial application in some field or the other. And that we have to mention in our specification also. Now we come to this procedure. Procedure is the complete thing, like you people are sitting on one side, we are on the other side, and then comes the patent office. Because there are three people working together for your one patent to be granted, right? Now you are developing, you are the creator of it, you are writing down something, you are giving it to us to draft the specification, we do the drafting, and then we file it with the Indian Patent Office. Indian Patent Office examines it and they take the call whether the patent would be granted or not granted. Okay, but any patent, let me tell you, cannot be refused till they give you a hearing in the matter. There is a law, there is a section that they cannot outright refuse any patent application. They have to give a hearing. Maybe after the hearing they are not convinced, they will refuse, but they will always give an opportunity to be heard. Now what happens is, once you write down something, for us to study that, to understand that and to draft the specification, it takes time. Because that creation is your creation, not mine. I have to first understand that and then put it in words. And drafting of a patent specification is a techno-legal document, as I told you. Then each word plays a very important role. What you place, what you not place, why I am writing comprising, why I am not writing comprises, why I am saying including, why not saying. So these are not debatable. I can't go into so much of details today, but that is important. So we have to really put in our effort to draft a specification. So if you part with your invention, that after 3-4 days you cannot think that we have drafted it. It takes time. We have to give us the time also, because we also have to do justice to what you have given us for drafting. So that we have to keep in mind. Now, the procedure of filing is, you file a patent with the Indian Patent Office. After 18 months, that patent is published. After 18 months, that application is published. It goes after the publication. You are given 31 months time to file request for examination. After that request for examination has been filed, we go for an office action is issued. Office action, you get 6 months time to comply with the requirements of the Indian Patent Office, and you get another 3 months extension upon payment of fees. And then after that, they'll again examine the application. If they are satisfied, it proceeds to grant, that is my right hand side. And if they are not satisfied, it is refused. When it is refused, you can challenge that order of the controller at the IPAB. There's no IPAB right now. There is an IPD cell in high courts. You have to go there. And again, there will be hearing, and again is rejected or allowed. Similarly, with the ones that are granted patents on the right hand side, it is again notified into the journal. And then if somebody is interested in your invention, might file a post-grant opposition. Then again you have to go through the opposition proceedings. And if there's no opposition, then it proceeds to grant. And there's one year time for a third party to file an opposition at the post-grant stage. And at the pre-grant stage also there is another opposition in India. That is from the time of filing the application till the grant, anytime anyone can oppose it. So this is a complete, so you have to imagine that how much time this whole procedure takes for a patent to be granted. Because this whole procedure has to be completed for a patent to be granted. So you cannot like all the time think, I have given it to them for drafting. That means, ho gaya, mera patent mil jayega. No. Procedure is long. Each steps have to be taken care of to ultimately give you a patent. Now, the next one is a very common question. People say, oh, I have a patent in India, so maybe it will be protected everywhere elsewhere in the world. It's not. Patent protection is a territorial right. Therefore, it is effective only within that territory where you are filing it. If it is India, it is only India. If you are filing in US, it will be only in US. If you have to file it in, if you want a protection in Europe, you have to file an application in Europe. It's not that patent will extend to Europe. And people very commonly say global patent. Global patent kuch word hi nahi hai. There's nothing called global patent. Patent you have to apply in each country to get a protection. It's a territorial right. And when you do this, there are options for doing it. Either you can go it for convention applications or you can go through a PCT route. I'll come into that. So therefore, if you want protection in just 2-3 countries, then we normally advise that you take a convention application, file in India, and within 1 year, file in the countries that you want to seek protection. That is convention filing. And if you don't want a protection in a number of countries, in that case, we normally suggest filing a patent cooperation treaty, that is PCT system. PCT system is an international system. And here you file it in India. Procedure is quite simple, and you get an international search report. International PCT will be again published, and you have an examination option also. That depends whether you opt for that examination at the PCT stage, because PCT is not a granting authority; it's only filing of an application. Then comes your national phase, which is before the designated countries which you elect your protection for. Wherever you want to seek protection, you file in those countries only at the second stage. PCT filing system is not a granting system. At the time of grant, you have to select the countries where you want your protection. So in those countries, it will be granted, not in PCT system. Okay, it is just to make the filing procedure easy, we go through PCT because it's one search report, one filing. You don't have to file multiple number of applications in different jurisdictions, all that you save. You just file application in one language in English and then it automatically goes. Advantages in PCT over traditional route. This is in 19 months you get a for seeking protection in foreign countries. You get time to think which countries you really want because it's expensive. Foreign filing is very expensive. So you really need time to decide as to whether I should file or not file, whether I should spend that money. So you get time. No objection on formal ground, only technicalities they look into. evaluation of the invention through international search. You get a very good search report, a detailed one from the EP or US, whichever search authority you go for, and then comes well-founded opinion. And then you, if it is a small entity or an individual, then you get 75% reduction also on the fees. This is almost the same slide what we were just discussing. Seeking protection simultaneously in a number of countries, you can do it. Strength of the invention through search and examination, you come to know at that stage. And then you can do it. An opportunity to have foreign counterparts, and then 90% rebate in the fees for natural persons. Now, these are some invention stories that I brought. See, always don't think that an invention has to be a very big invention. No, not required. If you just put in your brain and if you make a simple invention also, that invention can also become very big at one stage or the other. Like this gems clip. If you are given a wire, a normal person, gems clip is a strip of wire actually. And it has been configured in this manner to produce this gems clip. It has been twisted and turned in that manner. So therefore, when you think of the invention, it is a very simple invention, a gems clip. It is a strip of wire and it is being configured in a manner that it forms gems clip. And this gems clip has earned so much of revenue in the country. Safety pin and this gems clip. It's just strip of wire. How you have twisted and turned, that has given you the revenue. So invention need not be a huge invention that you make a lot of changes. Even a small creative invention would, earn a lot of revenue. This
but it cannot be patented, right? Because it is made up of that wire only. Like, we also have safety pins made of that wire only.
No, it was patented in the year 1849.
It's there. It has been patented because that time nobody knew if you configure it in this manner that you will get a gems clip which has got so much of application. At that stage, now you're thinking, oh, to pata hi hai gems clip kya hai or safety pin kya hai. But at that stage, nobody knew. Look at the words and look at the revenue they have earned out of it. So these are some success stories. This is one. Another thing is this one. Those wet ring pull cans, what you have. Cans, how you open it. Just put your finger, pull it, and this is also an invention, and it has earned the revenue, and this is now passed on to Coca-Cola. It was not done by Coca-Cola. It has been bought over that invention. Coca-Cola is using it. So these are like very simple inventions. You don't have to put too much of it, but see how they have helped the industry. Now we get on to designs. It's becoming too long.
No, that's right.
So, and now patents have come an end too, because I've almost tried to cover everything what we can do in this small time. But now designs as we have already discussed a bit when we were taking up different forms of IPR. So here design means only the features of shape and configuration. I'm again repeating myself. Pattern, ornament or composition of the lines or colors applied onto any article, whether in 2-dimensional or in 3-dimensional forms. Now these are the and now finally what it says, I'm not just reading through the whole thing. It is term 15 years renewed after 10 years. First 10 years you get, and then you get another 5 years for design to be for a monopoly right for designs. Design is one of the categories of IPR where the design system focuses on the aesthetic feature of the article derived from its visual appearance. How you look at it, that gives a protection. How it is different from the others. That's all that you get from it. And that therefore only novelty is taken into consideration, as I told you earlier. Relevant aspects are shape, configuration, surface pattern, color or line combination thereof applied on the article, which produces aesthetic impression on the sense of sight. What is industrial design? Industrial design is one of the categories of intellectual property right. Only aesthetic value of the product is concerned. Products of identical functional aspect needs to be designed well to attract customers. The industrial design is relevant to a wide variety of products of industry like jewelry. Everything is under designs. Designs which are not registerable. If it is not new or original, if there is something in the past of the same shape, same size, same types, then it's not registerable. If it has been already disclosed to public, means there's no novelty in that design, it's already in the public domain, then not significantly distinguishable. If two looks very alike and you really cannot distinguish the two, then design will not be granted. And then you cannot have obscene matter on the design. These are certain examples of design bottles, shape and configuration of the products. Then this is a representation sheet I bought for you. This is how a design is being, in design you don't have to write a specification like you have to write in patents. Patents you have to really write a lot. All invention has to be described, the claims have to be done, the drawings have to be there. But in design, you just give the photograph. Photograph has to be taken from all angles. It is called from the side, from the top, all the views have to be given. Right view, left hand side, all views. Now what you write there, where is the novelty you have to point out to the controller? The novelty resides in the shape and configuration of the teapot as illustrated. No claim is made by virtue of this registration in respect of any mechanical or other action or any mechanism, whether or in respect of the model or principle of construction of the article. No claim is made by virtue of this registration to any right to the exclusive use of words, letters, numbers or traits. It's only the shape and configuration of the teapot that is to be taken into consideration for examination. That's how the specification sheet is written. So, for example, that you have a cooker, for example, and you have designed the handle. Rest of the cooker is just the cooker, maybe no, but your design resides in that. But you have to, in India, you cannot go for partial designs. So when you are doing, you have to take the complete cooker with the design differentiation in that design. And when you are writing the representation, you have to say the novelty resides in the handle portion of the design. That's how it goes. Here, like the complete teapot is new. So they have written that configuration of the teapot as illustrated. So you have to point out where the novelty resides, even in case of designs. And in designs, only novelty is taken into consideration. It's easier to get a protection also, faster also. Within 6 months' time of filing, you get a design protection. So even if you have spare parts or you develop any mechanical gadget, so if you have aesthetic and looks different, then you can go in for patent and design for that electronic gadget or mechanical. That's the advantage. This is my last slide. Thank you so much. Please so patient. I'm really grateful. I really enjoyed this session, and I hope I could. And you people could learn something from this, then that gives me pleasure that at least it was not a waste of time for all of you. You learned something and it was a good interaction. Thanks a lot to all the students once again. Thank you so much.
I think we can take a couple of questions.
Yes.
If you have any questions, please raise your hand.
Yes.
Thank you, madam, for this wonderful session. Madam, I'm from chemistry background. So we are same actually.
Yes, same.
So actually, madam, suppose I am doing some multi-step synthesis.
In a process.
Yes. So my final product is completely new.
Right.
And it is not published anywhere.
Right.
And but some of the starting materials is not new.
Right.
I'm just using those substance as my starting material or intermediate material.
Right.
But with this, I'm making some new chemicals or product. And with this product, I'm doing some new application actually. Okay. So shall it be patentable or can I means inform this invention as a both product as well as the process or only product?
You can do for both product and process because your starting material is the same. You have put in your effort in the process parameters, which has made those starting materials different from the product that was there in the prior art must be. You're getting a new product, and that new product is due to those parameters and or the sequence of steps or whatever you have applied to achieve that. So the process and product both will.
Okay. And on another answer, that is the thing that application, whatever we are not doing, some part of the application is known with the different molecules. But from our case, actually, we are getting the some confluence of the different applications from the same molecular structure without any further modification or any derivatization. So
I want a small clarification here. You are saying that this product that you have developed from the known substances, this product is new, but the application of this product is known.
partially known means with different kind of molecular system, this kind of application are known.
Doesn't matter, but your product is new. That product is a new product is giving you that action.
Yes.
You cannot claim the application of that product.
Yes.
Application is not allowable in India. You have to just claim the process and the product.
Thank you.
I have a question. Suppose we have filed a patent, and it has been granted also. But on the same topic, usually researchers are publishing the journal article also. So my question is how it is allowed? Like same process you have patented and you are publishing a journal article on that. Is it legally allowed or not?
See, journal article is different from patent.
Yeah, but the process is same.
The patent office cannot stop the journals from being published. These are two independent ways. That's from a educational way, and this is from a patent point of view. But as far as patent is concerned, when you have a patent application, if you have a patent application and you know that if you are going for a publication, journal publication, in that case I would always say don't go for journal publication earlier than filing a patent. Because first patent and then you go for publication. Because absolute novelty is required. That's an important aspect of patent, right? But journal publication is something not under patent officing, but publication they do look into when they are looking into novelty or inventive step. They do refer to non-patent literatures as well. That they do.
I will explain. So no one sees. Actually, you are saying right. There are two things are involved. Okay, in our publication, some idea will be there, right? So that will go for the patent. That invention you are filing for a patent. But the expression you are writing, right? That is the copyright. Journal will take the copyright. So there are two things are involved. It's something like shirt and pant. It's a separate thing.
We will cite the patent also. And,
yeah, because the patent you are filing the patent, you are protecting the invention. I mean your idea. So you are protecting that, but you are not protecting the copyright. I mean literature, the way you are writing your journal. So, but if you do first literature, I mean publication. So in that process, idea also will
share with
the public. So that is better product idea, and then you publish. Okay, so
First,
publication, copyright will get it. I mean publisher will get it. Actually, he will assign. You will assign to the publisher.
It's always better to go for patent and then go for publication. Any other questions? Yeah.
So one question I had was suppose a product already exists in the market, but it has not been patented. So suppose I file a patent for a similar product, do they look at pre-existing patents, or do they look at the entire thing which exists in the market?
They look into everything. For novelty aspect, you're saying?
Yeah, suppose I made a process or product, and companies decide not to patent it sometimes, right?
Right.
So another company comes and it tries to patent the same thing.
So can the second company stop the first company which already had the product from producing?
See, if you file a patent, if the second company has filed a patent and the first company has produced it and not filed, the second company will get the advantage because
Even
of
if
filing
it's
the
documented that this company has been producing it for 2 years, 3 years, and they made it first.
No, but how is it to be proved that it is from 2 years or 3 years that they have been producing?
Like the product being sold in the market is not enough evidence.
Sold in the market there will be a novelty aspect on this application when they file this application. When they file this application, novelty, when they look into novelty, if it is sold in the market at a large scale, then that would be cited against this, or for sure.
Okay, so because it already exists, it will like.
It will be cited against this. For novelty, it will be cited, yes. Which is identical, if it is identical. Because that's why it says patents require absolute novelty. When in that case, you cannot even, if you have an idea overnight, you should not even disclose that idea to your friend even. Maybe tomorrow he goes and files a patent, you are still in the idea stage and you could not file it. So then your friend would be benefited from that.
Same thing happens with the Rasgulla, ma'am.
Yes.
Yes.
Yes, that was a dispute actually.
There's a general narrative that IP in India is not defensible, and companies don't want to come to India because their IP might get stolen. So, like, what are the differences in the laws? Like, why is that a narrative? Like, compared to the West, like, what is the difference in India?
See, laws are the same. Novelty, inventiveness, and industrial applicability is the basic criteria all over the world. But why companies are not coming in is the example I gave you. But Indians, like with the new products, they are very quick in copying the things. So therefore, sometimes they take precaution on that whether how to make an entry. Therefore, what happens is, I'll tell you, there are companies like now General Motors is not working in India anymore. But what General Motors used to do, when they used to file lot of patents in India, their main invention they used to file, and they used to file peripheral patents. Peripheral patents means relating to that, they used to file n numbers of other applications relating to that technology. But the main technology, they knew which one is their main one. Okay, just to protect that main thing, they used to file 10 other patents as a peripheral patent, so that people don't get to copy it easily.
But knockoffs can also be made in US. Like, why is India considered one country where they think that IP is not defensible?
No, India is now they don't think. Now India is also the courts are giving very good protection to the foreign nationals as well. Previously, they had this feeling like we have today for China. Which for China also we think they only look into their own people. They don't protect the foreign people filing invention into China. All that is there still. But India also had that reputation few years back. But now India is not in that place anymore. Now foreign companies are getting protection if they really have done the right thing. They are getting protection by the courts. A lot of previously, it used to be most of the settlements used to be out of court settlements. Now they are also granting a lot of damages to the companies. So now people are not complaining anymore. This is what you are talking about maybe 5-6 years down the line.
I will explain one more point. See, actually, we signed a treaty which is called the TRIPS agreement. So almost 190 countries are part of the TRIPS agreement, where it says this national treatment. It doesn't matter, like, if localized files a patent or some foreigner files a patent, he will get the same treatment. So you are saying that enforcement issues, right? Like, why people are not coming to India. So it's not like that, because we are obliged to the treaty. See, once you are obliged to the treaty, so if it is filed in the court, because national treatment says that anybody is equal, and independence of the patent also, one of the obligations, which says that if it is rejected in some other country in the world, if you file a patent, same invention, it doesn't matter, like, if it is failed in other country, doesn't mean that it should fail here also. It may get granted also. So these two principles are there. So definitely enforcement, you cannot say. For example, you can say in US enforcement is like, bit faster. Like, because number of people are less and, police system is different. But coming to our India, like, enforcement bit slow. But We are obliged to the treaty, and definitely it should come. In the legal terms, I have told.
Do we have any more questions? Thank you.